All right. Welcome. Civil Rights, Chapter 5 of your text. This is for U.S. Government, Seton Catholic Preparatory. And we just finished Civil Liberties. Time to get into Civil Rights. Today you're working on an assignment from your reading dealing with the scrutiny standards. We are going to cruise right past those slides here on our way to a couple of our main topics today. But let's talk briefly first. What we're dealing with here, civil rights, right of all Americans to equal protection under the law, as opposed to the Bill of Rights, which is protecting our liberties. Okay, so we have laws, we're going to see here examples of civil rights, right to vote, public education. We certainly know and believe that we have these, and government is to provide these. And we have laws that establish our schools and a right to vote and where we vote and all of these things, the requirements. And we just have to make sure that we are protected equally, that our laws make sure that if we have a right to do that, that we receive that and are, cannot be denied. So that's the essence of civil rights as opposed to civil liberties. Now, we're not going to get into the scrutiny standards. You're doing, again, the reading assignment has to do with these. Quick answer to the who determines what compelling means, because you're going to want to go through all these slides yourselves. But the courts, of course, it's always the courts that decide these things when there are challenges to the laws or how they're being enforced. By now you've read about under strict scrutiny. These are all the protected classes. Not a problem here. That's just it. We want to make sure our laws don't discriminate against somebody because of their age, their race, their national origin, their religious belief, any of these things. Now, interestingly, there, of course, are also not protected classes. I'm going to add a couple. I highlighted a couple here simply because these are the things we're discussing at this time, too. You see that. Are we going to give illegal aliens or undocumented aliens the right to vote? People with criminal records, are we going to extend voting to those in prison? We see that in the states. So those seem to be on the agenda for a lot of our states too. Now, I'm going to stop here really quickly. As you read about this, you would have also read about this in Chapter 4 under Civil Liberties, under freedom of religion. It's important in this case too because it's the clash of the practice of religion, religious belief in the First Amendment, the very first thing listed in the Bill of Rights, with the desire for the government to educate its people. Now, should we have the government interested in education? Absolutely. Why not? It seems reasonable to have our government involved in making sure that we are, as a population, educated to a reasonable degree, okay, to have a well-functioning, well-ordered society and system. Now, that clashes with the practice of religion here, but in this case, while they're interested, the government interest is not compelling enough to interfere with their practice of religion. And the court sided. In this case, religion won the day and continues to do so. Now, we won't get into this. Intermediate is always fun. Great discussion because it does allow us to. There's a standard that allows us to discriminate against women, strangely enough. And these you should be familiar with also from your reading. A lot of them explain themselves. A literacy test. You have to pass a test. So you're literate or smart enough to vote. A poll tax. You have to pay to vote. Grandfather clauses. Did your grandfather vote? Well, then you can vote. Okay. Interestingly enough, obviously, these things are designed, or at the time were designed, to disenfranchise former slaves, those who had been on the plantations and are now worked out into society, to keep them from voting. It did, but it also discriminated against people of other races and discriminated against a lot of whites, a lot of poor whites in particular. So, and it was acceptable at the time. And with the grand scheme of things, what they're aiming for, those that were not intended but were discriminated against, it was accepted that was okay. But make sure you're familiar with those from your reading. Now, separate but equal. You guys have all heard about this. We've discussed it in the past in other cases. Separate but equal facilities in the past. Supreme Court did say separate but equal was constitutional. And we discussed this when we were talking about the judiciary and whether or not they were going to uphold previous decisions. And we talked about the stare decisis and whether or not, if somebody is going to be appointed to the Supreme Court, will they respect previous decisions? Well, this is an example of one of those decisions that should never have been respected. Unfortunately, was not. Okay, separate but equal. It was determined that separate was never equal, and there were no equal educations being found in these separate schools. So, therefore, people were not being treated constitutionally. They were not being treated equally under the law. So, it could not be allowed to exist. Strangely, speaking of stare decisis, for the Brown case, there was a new Chief Justice. When the case first came up, there was a Chief Justice who was probably more inclined to uphold the earlier decision of Plessy versus Ferguson. But once Earl Warren took over as Chief Justice, and we went into a very liberal stage or liberal time period for the Supreme Court, we found that the opposite happened. And so for that, just for this reason alone, just for this reversal, it was definitely well worth it. And certainly Brown versus Board of Education righted the ship that needed to be righted at that time. Okay. Now let's talk about de jure versus de facto segregation. What's the difference? And you'll see this. You'll see references to de facto this or de facto leader of something. Excuse me. And what it means is, one is established. Let's say we, excuse me, we have somebody who is the head of an organization. The people voted that person in or got the job, however it was, legally. They hold it by law. But other people, somebody else may be recognized through their opinions, through their actions, as the person people go to. Okay? I'm going to use this, for example. In late March, I was looking at recently looking at some postings from late March in which Bernie Sanders, he hadn't dropped out yet, but he was being viewed as the de facto leader of the Democratic Party, even though Biden seemed to be marching towards the nomination. The reason? Well, it was ideas behind the COVID pandemic. Sanders was seen as the person coming up with the ideas. In fact, at that time, even wasn't just in the Democrats, but the Republicans were thinking his ideas probably weren't that bad. Were pretty timely considering the pandemic. So people were looking to Sanders more than they were to Biden. Biden was very silent on the issue. And so Sanders was the de facto leader of the party, even though he wasn't winning. And he's not going to win the nomination at this point. So that's kind of the difference. And I hope that helps explain it. So what's the purpose? Well, let's talk about segregation. Did school segregation end simply because of the Brown decision? Because of law? No, it did not, in fact. And I left out one of the things on this point, which I want you to add after redrawing school district lines and busing. And I want you to add, lack of or pulling of funding. Because even though the courts said, okay, great, the law cannot establish separate but equal facilities, there were other ways to do that, simply by redrawing or gerrymandering school district lines, you remember that term, busing students from one area to the next, or even withholding funds. Some districts decided not to fund certain schools, so they just ceased to exist. So by law, segregation didn't exist anymore, but by circumstances, in fact, it continued to exist for quite some time. Now, let's get to the few things. This is what is called the Civil Rights era, and this is where I was headed. The 1960s are generally referred to as the Civil Rights period, okay? And that's where a lot of the activity, a lot of the violence, a lot of the protests, a lot of different things were going on. The 60s were quite the turbulent time. But the civil rights part of it actually began in the 50s and even before, okay? Now, interestingly, President Eisenhower, who the Democrats are seen as, they became seen as the Civil Rights Party during the 60s, Eisenhower was actually a Republican, and he used the troops to desegregate schools. When National Guard and local police and everything refused to do that, he actually stepped in and used the Army to desegregate schools. He was very much a desegregationist, wanted the end of discrimination, and was not shy about using, his office to get that. So, but he introduced the first legislative action in 1875, and he wanted to protect voting rights. He wanted the law to make sure people who should be voting were. And he also wanted to increase black voting in the South, especially in the Deep South. Okay, the Republican Party at that time was the party, if you remember, the party of Lincoln. It rose against slavery and against discrimination, all of these things. And he was kind of continuing that progression. He established, of course, a Civil Rights Division in the Department of Justice and a Civil Rights Commission to investigate. So this was all part of the first Civil Rights Act of 1957. It wasn't that effective, but it does set the stage for the next couple of things. Okay, Civil Rights Act of 1960. Okay, again, Eisenhower trying to close loopholes, strengthen the Civil Rights Act, wanted the government involved in looking at the voter rolls in the states to make sure people who were supposed to vote were being allowed to and were voting. He wanted to start penalizing people and prosecuting for interfering with even court orders for desegregation. Again, he was this whole desegregation guy at that time. And so he was very, very aggressive in his pursuit of both ending desegregation and getting people to the polls. But we're looking here, and again, it's signed in 1960, but all of this started in the 1950s and under Eisenhower. Now, we get to the 60s. Most people, when they're talking about civil rights, they look to the Civil Rights Act of 64, and a lot of people believe that this was the first Civil Rights Act. Clearly, it was not. But it's considered to be one of the crowning legislative achievements, as we say right there. It really broadened it, okay? And there were 11 titles, 11 different articles in this act, dealing with a very broad scope of civil rights, which we'll not talk about right now. But, again, people looked to this in 1964, but if it wasn't for the previous two, I don't know that we would have had the Civil Rights Act of 1964. But it was critical. Again, Lyndon Johnson signed it into law and pushed it through. However, interestingly, he wasn't the person that came up with it. It was John F. Kennedy, prior to being assassinated, who actually initiated this, and Lyndon Johnson then was able to push it all the way through. So, but again, banned employment discrimination on the basis of race, color, religion, sex, or national origin. Okay, we see the civil rights period in the 1960s as being primarily about race, but it involved a lot of other things. And that's what the Civil Rights Act of 1964 was about. All right, so then Voting Rights Act, a year later, Voting Rights Act of 1965. Okay, definitely an extension of what Eisenhower was doing. Suspended literacy tests, got rid of a lot of different things. Now, of course, Eisenhower's not president, but it was the beginning of the end of poll taxes. And this is, again, pushing forward the idea that people should be voting, that citizens should be voting. We had to make sure that they did get the chance to vote. We increased the voter rolls of all minorities, of anybody that was being denied that, and was successful. It was what Eisenhower started and was continued with the Voting Rights Act of 1965. Was very successful, to the point that we have this question: what case changed part of this? Shelby County versus Holder in 2013 actually did find that they had accomplished their goal and ruled a Section 4, okay, in Mississippi. In fact, I don't have the stat here, but we do there in that one note, black voter registration actually in Mississippi exceeded white registration. So definitely there in the Deep South, this whole, the segregation, the voter rights movement was extremely successful. And in this case, then the Supreme Court said, great, in this case, we're finished. And that's the end of this one, and we'll talk soon.